All right. So this week started out with, not much happening. They had assigned a new judge, Judge Ingram, right? And quickly she recused herself. It took like no time. Um, Will you have ownership in the creation? No, because I'm working for the company, I'm doing a project for the company, I won't have ownership, but I have ownership in my code. So let's say I went and moved to another company, or let's say I want to go start my own business. I could take my code with me and just go recreate it on my own for my own applications. Shout out to Ked once again, man, showing great love to the people, to the good people at the regular podcast. It's going to be almost time for us to get Ked back in here. Once we get another, I say we're going to get Ked back in here if he's available. After YS or after Lil Woody, after Kenneth Copeland is finished testifying, we're gonna bring Ked back in, and then we're gonna do a deep dive and see how the people are feeling about the whole testimony. But again, it's a lot going on just based on what we heard today. So Judge Ingram actually recused herself, and the reason she recused herself, and I'm gonna pull it up here because it is very interesting. Give me a second. Essentially, she recused herself because there might be, because there's not an actual conflict, but there could be a perceived conflict, and she doesn't even want to deal with it. So I'm gonna go ahead and put this up on the screen for the good people to watch. Now, this is what Ingram had to say. Let me put it on my big screen so I can read it, and y'all can read it on the screen along with me. So I'm going to read the meat and potatoes of it, essentially. On or about June 1st, 2023, Christian Eppinger, one of 18 defendants, was severed from the ongoing YSL RICO trial on a criminal action that was recently transferred to this court by random assignment. When she said this court, she means to her courtroom, Judge Ingram. Although there were no severance order on the record, the court was apprised of the circumstances that directly led to Eppinger's severance. More specifically, the deputy assigned to and responsible for the courtroom personnel security or personal security of the undersigned for nearly 6 months was arrested. Said deputy was still assigned to the court at the time of her arrest, is accused of 1. Colluding with defendant Eppinger during the current trial to commit a felony, and 2, endangering the safety of citizens within the Fulton County Courthouse. Because this court's former assigned deputy could be called to testify in any future proceedings in this case, the court may be called upon to assess the deputy's credibility or rule on matters related to her criminal prosecution. This may undermine the public's confidence in the impartiality of the proceedings. Now, do you see the main part that people need to think about is the last sentence of what I just read. This may undermine the public's confidence in the impartiality of the proceedings. Why is that important? That's important because that's a common thing that we keep on running into and discussing when it comes to the Fulton County courthouse proceedings. Not just the YSL trial, Fonnie Willis trial, and a couple other things going on. Or Fonnie Willis disqualification hearing, also the Donald Trump trial, all this type of stuff, right? When it comes to impartiality, it's not a matter of somebody having to prove you as a judge or you as a prosecutor are impartial to the defendants or the prosecution. It's not about whether they can find actual proof of it. It's about the appearance of it. If there is an appearance of it, if it can be questioned reasonably whether or not you can be impartial in the matter at hand, you should recuse yourself or you should be recused. Really, you should recuse yourself like this judge did, because why even get in the middle of that when you know there could be a possible issue coming up? Yes, please hit the like button. This could cause a possible issue, right? One of her deputies helped Christian Eppinger do some BS that she shouldn't have been doing and that he shouldn't have been doing. And it happened to happen in this lady's courtroom. So she said, you know what? I'm going to go ahead and recuse myself. So that took no time. I mean, the defendants wanted her recused anyway because they actually wanted her, like Weinstein wanted every other judge in Fulton County to recuse themselves. He wanted it to be moved to another jurisdiction. But that didn't happen. So it moved on to Whitaker, right? Moved on to Judge Whitaker. And Judge Whitaker's full name is Judge Paige Reese Whitaker. I actually want to pull up her page because I think it's good to note. Let's see, what am I looking at here? What's window capture? That's not what I want to look at. What's this window capture? That's not what I want to look at either. Give me a second here, guys. Okay. Let's look at Paige Reese Whitaker, because there's some important things I want us to note about this lady's background. Excuse me. There's some important things to note. Hold on. Let me adjust this. Okay. I don't want to cover myself up with the joint. Okay. Now, Judge Paige Reese Whitaker, okay? She's been a Superior Court judge since 2017. She graduated from law school in 92. But let's look at her professional experience. Of course, she was a deputy district attorney. Okay, so we see that there in Fulton County, specifically in the district attorney's office. But one of the things I think is most glaring here, she was on the board of governors at the state bar of Georgia. Now, if y'all don't know, if y'all don't live in the area, pretty much everything related to state matters is like downtown Atlanta. So, yes, it's not part of Fulton County, but she's been downtown Atlanta all this time. So, the state bar, now the reason why that's important here, and it means that she has a specific set of skills and expertise as it relates to professional conduct by lawyers. She was on the board of governors at the state bar of Georgia, meaning she knows how lawyers are supposed to conduct themselves, and we're going to get into that later because she laid out some groundwork, some ground rules for the way her court is going to continue going forward, and it almost was like a warning / threat, pretty much. And I actually heard her say this stuff before I went to her bio. So her bio saying that she was on the board of governors at the state bar of Georgia actually makes a lot of sense why she gave the courtroom the warning that she gave today. And we'll get into that. But she does have a lot of experience, Georgia Commission of Family Violence, Women's Policy Institute, Leadership Academy, treasurer. She has an extensive history of being, not only having jobs in the legal field and high level jobs, but she's part of a lot of organizations, meaning she has a lot of brethren of the bar. She congregates with the people of the bar often, right? So she has relationships. We don't know who her relationships with so far. I saw an interview with Max Shard on Megan Cunning's show. Max Shard seemed to be pretty fond of her. And one of the early things that she said in the courtroom today, she pretty much said, hey, Mr. Shard, Attorney Shard, you know my courtroom, so you know how I operate. So that was not, that to me, that was pretty much the only lawyer that she said anything like that to. She's very familiar with Mr. Shard, and he's very familiar with her. He says she's a great judge. He says she's a favorite. She has been favorable to him in the past, showing him a lot of grace. So I don't know exactly what that means as far as how she'll look at some of the stuff in this trial. But I do know that the Board of Governors at the State Bar of Georgia is, to me, the most important thing that we should be looking at and paying attention to here, right? So be on the lookout for her to enforce what she's talking about, okay? I don't think she's here to play around at all. Now, she ended up calling a hearing today for the lawyers only. No defendants, the media, the cameras were there, but it was just lawyers only, right? Because she pretty much wanted to meet everybody, wanted to get familiar with everybody, she wanted to make some announcements to people. Hey, this is what we're going to be doing going forward. This is when we're going to pick up. This is how we're going to be treating it. Like, she did that whole thing, right? So, we still have a long break pretty much. They won't be reconvening with any court matter until the 30th of July, right? Now, y'all tell me, did I hear her right? She wasn't saying that the jury is coming back on the 30th. She was saying, I will see all of y'all on the 30th, right? She's pretty much giving everybody a chance to get all their emotions together, get all their responses together, discuss the evidence and potential admissibility. She want them, work together as much as y'all can to gather all documents that you need me to see, send it over to me, and let's start working off the clock. Let's start working when we don't have a jury here, because what I don't want to do is bring the jury in here, have them sitting in the back all day while we go over motions and things like that and evidence and stuff like that. So she's like, don't do that. I don't know what y'all been doing before. I'm not doing that. So that's kind of a breath of fresh air. We don't have to sit through hours and hours of of evidence, admissibility hearings, essentially. She said she wasn't going to argue anything today, but she wanted to know, hey, what open motions do you have that I need to consider? What motions do you have that I need to look over? Send them to me. Let me know right now. She said, hey, I understand that y'all want some stuff looked at again. I don't have time, and none of us have time to go back over things that have already been ruled on. So if the judge ruled on it already before, I'm not going over it. I think that was good, because who has time for that? I don't, Let me turn this off. Who has time to be going over all of that? What else did this lady say? I mean, I'm not going to lie to y'all. If I'm not mistaken, Kayla Bumpus was on stream with a few different people, right? I think this was before she started her own YouTube page. She was on stream, and I think Miss Sylvia, and I got familiar with Miss Sylvia, not because of her page, but because she jumped on a live stream with Bumpus and Nick and somebody else. Shout out to her. Miss Sylvia said something like, hey, what if I think she said Judge Ingram, because she said she liked Ingram. And Bumpus was like, no, like she didn't like Ingram. So I was kind of, I think that's who she said she wasn't really feeling. I think she said she hopes she don't get it. Okay, so let me keep on going through, because they was rolling and grooving. So then Brian Steele comes up, and I feel like Brian Steele dropped a bombshell type of situation on us. I wasn't familiar with this. Nobody else brought it up. But of course, Brian Steele, being the seasoned veteran OG lawyer that he is, Brian Steele said, he came up there and said, hey, I want to put something, you know what I'm saying? Let me, what the old head say, let me pull your coattail or something. He pulled the judge's coattail and said, hey, judge, we got this case law here. And essentially what it says is, from the time a recusal motion is filed, from the time it's actually filed with the court, and anything beyond that, anytime a judicial recusal is filed, and up until the time of actual recusal, nothing that happens in that period is valid anymore. So let me break that down if y'all didn't hear it, because he explained it all. He's pretty much saying, when Doug Weinstein made his initial motion on June 12th to recuse Glanville, right? Glanville denied it. Then Weinstein actually filed it with the court on June 14th. That starts the clock, right? He filed it, so that starts the clock. Sometime later, a couple weeks later, Judge Krause recused Glanville, right? But between that time, we heard testimony and we heard a lot of argument about Woody on the interrogation videos, which is like 15 hours worth of video, and then like 2 hours worth of jail calls, right? Remember, there was weeks from the time they actually put the recusal motion in to the time they actually recused him. According to the case law that Brian Steele brought up, everything that Kenneth Copeland testified to in that time and all the arguments that they had is all invalid. Pretty much it all has to be done again, right? The reason it has to be done again, the jury heard it, but it was under a judge that was running the courtroom a different way. Even everything the judge said needs to be removed. All the notes that the jury took need to be removed. Everything that happened from June 14th up until pretty much today should be thrown out and regarded as invalid. That's a bomb. That's a bombshell. I consider that a bomb, because I haven't heard anybody else mention that. I haven't heard anybody else mention that at all. Let me bring that let me bring this image up, because let's read through it a little bit. Let's read through it a little bit and see what Brian Steele was cooking, because Brian Steele be cooking. You gotta really, tap into what Brian Steele be, whipping up. So essentially what he said is the motion to challenge factual findings not result of the Honorable Judge Krause's order dated July 15th, granting the motion to recuse Judge Glanville. So essentially, a month worth of things were happening. And Brian Steele is saying it should all be invalid based on this case law. Let's see what he says. Comes now Jeffrey Williams, by and through undersigned counsel, and hereby files this motion to challenge factual findings not result of the Honorable Judge Krause's order dated July 15th, granting the motions to recuse Judge Glanville in the above referenced case. In support of this motion, Mr. Williams shows as follows. Mr. Williams is innocent of all crimes in the above referenced indictment. The Honorable Judge Krause made two findings that are respectfully erroneous in her order granting the recusal of Judge Glanville. Mr. Williams is not challenging the result of the order, but rather the following. Krause wrote, divorced from its hyperbole, Mr. Williams' motion and supplement also seek to recuse Glanville because of his involvement in the ex parte meeting, which Mr. Williams also alleges was improper and coercive. Okay, there is nothing hyperbolic in Mr. Williams' motion to recuse and affidavit in Mr. Okay, let's see. So Brian Steele is just really getting his cook up. He's getting his cook up going before we get into the meat and potatoes. And actually, I don't have the full motion, so I have to go by what I was actually able to find online. The full cook up. Let me see. It is worth noting that the Honorable Judge Krause agrees generally with Glanville's assessment of the propriety of the ex parte meeting, while the meeting could have and perhaps should have been taking place in open court. Nothing about the fact of the meeting or substance discussed was inherently improper. This finding is wholly against the law. At this improper ex parte meeting, Mr. Williams and his counsel had a right to be present for several reasons, including but not limited to the fact that Mr. Copeland provided statements not only bearing on the substance of his testimony, but also on his credibility. There was an enormous amount of Brady evidence shared at this improper ex parte meeting with the lawyers Love and Hilton and Judge Glanville all attempted to keep secret from undersigned counsel, and there is no lawful reason for this ex parte get-together. Okay, so I don't have the part of it where he cites the actual case, but he's essentially correcting some of what Krause said, and then he's also, in that whole motion, this longer part, he said, hey, everything that happened from June 14th to July 15th should be deemed invalid and disregarded. And we actually need to also go to the jury, let them know it was all invalid. And we need to take every note that they took on every single one of those days, which was like, I think they said the afternoon of the 14th, the 15th, 16th, 17th, whatever he said. It was a few days where Copeland was still testifying that Brian Steele says we need to get those notes too. Now, another thing, right? So the judge said, hey, we're not getting into any argument, but let me know what I need to be looking at. And she told Brian Steele, because he didn't file it yet, but he told her, hey, I can file this if you need me to. And she said, definitely file that with the court. So she'll have it today and she can look over it and make a ruling on it. And I'm kind of like, I don't know this judge, but I'm just kind of sure that she will throw all of that stuff out that happened from June 14th up until July 15th, because it wouldn't really make sense for any of that. That's just confusing. You see what I'm saying? So that would confuse them. They might throw all of Kenneth Copeland's testimony out and make him start again. I don't know. We'll see. Also, because of what Brian Steele put in this motion, he's saying, I need you to re-look at the validity of that ex parte meeting because it was against the law. So she can actually rule on that again too, I guess. Or she might say, hey, that has been ruled on already. I'm not getting into it because we need to move on. She could say that too. You never know. Now, the judge gets into her new rules that she is setting forward in the court, right? So essentially, what she's saying is, I'm going to go down the list and then we can talk about it. Okay, so she pretty much said, hey, court from now on is going to start at 8:45. And when I say 8:45, that means I'm in my seat and y'all should be ready to start presenting the case at 8:45 and we get into it. And we'll be going till about 6 p.m. every day. We need to move this thing along. So one thing that she said that I thought was interesting is that I haven't been following this case like that. I'm just now really getting finding out what's going on. But I started talking to people recently, and I'm hearing some things that we got to change this stuff. I don't know what y'all had going on, but 8:45 to 6 o'clock, like let's get to it, right? She said there's no more eating in the courtroom unless the court goes overtime and people can't get access to food or whatever. Stop eating in this courtroom. I don't want, or just stop eating in this trial. I don't want it happening. She said that she's been getting complaints from the deputies, the people who help, get the inmates ready in the morning or whatever, the defendants in this case. She's saying, yo, I'm hearing that y'all have some type of excessive wardrobe thing going on. Like, why do y'all have so many outfits back there? If y'all want to share clothes, that's cool, but y'all can't just yo, dial it back a little bit on the outfits, on the wardrobe. Like, if y'all have 5 outfits, that's fine. One for every day of the week. But we're not doing 20. Like, come on. So that's pretty much, well, that's you would think that that's like a Young Thug thing, but a lot of them been coming in court kind of fresh. I'm not gonna lie. They've been coming in there with it on. She said also that she also has gotten word, and she's been seeing a little bit, that there's been a lot of disruptions in the court. And she didn't really elaborate on what she meant. And she said that she heard this from somebody else told her this. She might have said Glanville. She might have said Glanville dropped this little nugget on her. But she was like, yo, listen, all the disruptions in court, that's going to stop. We're not doing that. By disruptions, I'm trying to figure out like maybe she means like arguing back and forth. But she kind of rolled this into the thing about professionalism. And we definitely got to get into that. So no more disruptions in the court and being professional. Like I said, remember I said this lady was on a board of governors at the State Bar of Georgia. So when it comes to prosecutorial and just lawyer, even defense attorney, conduct and professional conduct, I would consider her an expert just based on her resume. I would consider her an expert in that field. So, and I think everybody else they probably know who she is, so they probably won't play with her either. Everybody seemed to be on their best behavior in court today, so we'll see how that goes. Defendants cannot be using headphones. So essentially, and I'm actually reading off of Thugger Daily's list. I wrote my own list, but I just like how I wrote way more explanation, but this is just a list Thugger Daily put together. So I'm going to just read off of this. They don't want them using, she's like, why are they even using headphones at all? I'm hearing that they're like listening to stuff on laptops and cell phones and all. Like, what are they doing in here? So she's like, nah, that needs to stop. I don't even know what it is. One of the defense attorneys said, oh, they get bored sometimes or because of boredom. She's like, that's not a reason to be on headphones. Like, y'all need to figure that out. And I'm going to make sure that nobody else is bored now because we about to move this thing along. Then Mr. Matthews, Marquavius Huey's attorney, stood up and said, hey, sometimes I let my client hear things that we weren't able to listen to behind the scenes or whatever, like about evidence. Maybe there's some recordings, some jail calls, something like that. And I let him hear it while we in court. The judge is like, that's cool, but like, why are y'all not doing that outside of court? That should be happening before we get in the courtroom, not inside the courtroom. He's like, yeah, I don't get that much time with him because we be in trial all day. She's like, yeah, that's cool, but pretty much try to handle that outside. Like, we're not doing that no more. Cut the headphones out for these guys that's in jail. That's not happening. And I guess people are saying, the deputies who told her about this are saying this is a security hazard, pretty much. I don't, whatever, somebody could be passing information. I don't know. And no more gaps between witnesses, and the state needs to make their next witness available immediately, pretty much saying that all of this long pausing and all, like people not being prepared to testify or somebody having to take a break and all, like somebody need to leave and go somewhere else instead of coming here to testify when they are subpoenaed. No more of that. You need to be ready and available. Another thing when it comes to the witnesses, she said that y'all need to continue the thing of giving up your witness list. And she actually said by next week, I need y'all to give me a full list of the witnesses that you have left, and you need to tell me what they plan on talking about. Because she's like, there's a law that says that I can get rid of some witnesses due to them being cumulative information and stuff that's repetitive, pretty much. So she's like, if I see too much, like if you keep telling me that these people are going to talk about a bunch of the same stuff, I'm going to go ahead and like I'm going to get on the chopping block. Okay. Glanville said the same thing, but he never actually did. He never actually said, yo, y'all can't call that person because that's cumulative. Even though we heard like a bunch of people say the same exact things, Glanville never actually enforced that. Now, I do want to I do want to listen to the part where she's talking about professionalism, because she said it and she's kind of like laughing her way through and anxiously laughing her way through, but she's really, it's a warning. It's really a threat, right? And I knew she was kind of warning them and she seemed pretty serious, but it really hit home when I saw her resume and I realized she was on the state bar board of governors. Hold on. Let me get my headphones off. Let me get my headphones so I can listen with y'all. Let's get this video cracking. Hold on, y'all. Okay. Let me get this going here. Let me get this going here. Window capture. Boom. Okay, that's not what we want. Let's go ahead. Listen to how she's nervously, anxiously laughing her way through this thing, because she's serious and she's really not joking. Let's play it.
So I hesitate to even say the next thing I'm going to say, but I'm going to say it anyway. The little bit I have seen about this case, it definitely has appeared that there have been times that tempers have flared a whole lot and that people have been maybe less than professional. And I hope that this kind of breather has given everybody a breather, and everybody has been absolutely wonderful here today. But I would like for us to maintain a degree of decorum and dignity and professionalism. That is what is really expected of all of us as members of the bar. I don't want to have to say anything beyond that, okay? But if it gets to a point where I think that is not being carried out appropriately, we're going to all have to talk, okay? All right.
We're going to all have to talk. That was a threat. And I think that, what? Come on, man. Excuse me, y'all. I think that was, my headphones just, I'm over here living life like it's bronze. You know the song Living Life Like It's Golden. I'm living, my headphone piece of my headphone just broke. Like, what was that about? But, that is probably the most necessary thing that needed to be said to these people, on top of the thing about the time. But I think court was starting so late because of Glanville. I don't think it was because any of the attorneys. But I think that was such an appropriate thing to say, because it has been mentioned so many times, even by Glanville, telling them, hey, remember your professional responsibility or your duties to other members of the bar. You don't want to accuse anybody of anything. Like all this type of stuff. So this judge, in getting caught up in the case, said that she has been seeing things and temper's been flaring and a lot of energy has been happening. So whatever has been happening that she deems to be inappropriate, she's seen it. And she's pretty much saying, let's not let it happen in front of me. It's essentially like, it doesn't sound like she's going to give any more warnings. Like Glanville just gave a million warnings and they weren't even really warnings. He just talked to them like kids, like, hey guys, let's just come on, let's play nice with each other type of thing. She's seeming like this is her saying, don't do it. Not saying everybody gets 3 warnings and then you're out of there type of thing. It's saying it has happened enough. It won't happen anymore. That's what I heard her. That's pretty much how I heard it. It's over with now. All that Bush League shit y'all was doing, it's over now. So that's good, because like I said many times, and like a lot of people have been saying, I haven't really seen a court like this and lawyers acting like this in court. It has been kind of crazy to me. So They are recessed until July 13th. And at that point, they'll be coming back. The judge will be making rulings on some of these motions. She'll be reading some or allowing these lawyers to argue their cases. The jury is definitely out. So she said the jury is out on the week of the 29th. So the jury is not set to come back till like August 5th, I think. Or something like August 5th. And even then, if they realize that they have more work to do and it takes longer than a week, they'll push the jury back even more. So we are still 2 weeks away from the jury even coming back and us getting any more testimony. So we're a week and a half away from even seeing any more action in this court. So I don't know, man.